Can you hear me? Okay. All right. All right, good afternoon. Welcome to all board members, administrators, and business managers. Thank you for joining us for this month's NDSBA Lunch and Learn. It is 12 o'clock on October 21st, and we are streaming to you live from Bismarck. Amita Cook and I will be the NDSBA staff presenters today. Alexis Baxley, our executive director, is also with us online to help monitor any questions. Before we begin, I want to thank our session sponsor, Software Unlimited. Their link and contact information is on the screen. We are grateful for their continued support of NDSBA and encourage you to reach out to them with any school accounting software needs or questions you may have. Today's NDSBA Lunch and Learn session is meant to be a check-in on how your district is faring with the extensive updates recently made to the Title IX sexual harassment regulations. These updates were presented in early May by the U.S. Department of Education with an implementation date of August 14th. Unfortunately, districts and even our office did not have much time to digest the changes and to prepare. This definitely left us all scrambling. However, from what we hear, districts have been busily adopting policy, updating their websites, and offering the necessary training for their staff in the required time. So kudos to you on that. To begin our Title IX discussion, Amy will review some issues we have identified with the key provisions of the new regulations. Our time together today is meant to be participant driven, so your questions and comments are encouraged and will benefit our discussion, so please ask away. To ask a question, please either enter it in the Q&A box or click the raise your hand button found at the bottom of the Zoom window. When we are ready to take your question, we will call your name and unmute you so that we may ask your question. If you raised your hand, but during the discussion, your question was not answered, please click the raise your hand icon again to deselect. We won't be monitoring the chat as closely this month, so please use the previous two options. Today's session will be recorded and posted on the NDSBA website under the resources tab. And finally, just a reminder, you have all been muted. That's all I have for now. I'm going to hand it over to Amy to start the Title IX discussion.
Thank you, Rebecca. Let me just get set up here, make sure I got everything going. There we go. Okay, well, thank you again for joining us today. As Rebecca said, this session is really meant to be a forum for all of you to ask questions that you have of the new Title IX regulations and address any issues that you guys are running into. So please feel free to start asking those questions now. But to get started, I wanted to just identify a couple of issues that we've run into and the questions that we're getting so far regarding the new Title IX regulations. And so I'm going to just start moving through those. If you have any questions at any time, please feel free to ask. And then, of course, bring up any issues that you guys are seeing that might be different from what we have on our list here. So the first, I would say the most common issue that I've received calls on since the regulations were issued and then came into effect in mid-August is designation of Title IX personnel by districts. The new regulations significantly increase the due process requirements for districts to follow, and so that has led to districts rethinking who their Title IX personnel should be. And so in light of the new regulations, there's a couple of things I wanted to note. So first and foremost, each district is required to have an employee, at least one employee, designated as their Title IX coordinator. That implies that you can have multiple Title IX coordinators, and depending on the size of your district and your facility setup, you may have multiple Title IX coordinators. For example, you may have a Title IX coordinator for each of your buildings, maybe having a secondary Title IX coordinator and an elementary coordinator, maybe an employee dedicated Title IX coordinator. You have some flexibility, but the minimum requirement is that you have a Title IX, at least one Title IX coordinator on staff. And again, that coordinator has to be an employee of your district. It cannot be a third-party contractor. It has to be an employee of your district. And then in addition to the Title IX coordinator, ideally, we would recommend that you have 4 other Title IX personnel. Those 4 are an investigator, the initial decision maker that's going to be making the decision on the at the conclusion of the investigation as to whether sexual harassment occurred, and then the decision maker on appeal, and then finally an individual who would be facilitating any informal resolution procedure. So that means ideally, under the perfect scenario, you'd have 5 total individuals designated as Title IX personnel. So again, to review, your Title IX coordinator, an investigator, the initial decision maker on appeal, and then finally an individual who is going to facilitate informal resolution procedures. Oftentimes, so far, and I think this is how it likely occurred prior to the issuance of the new regs, the Title IX coordinators oftentimes designated by districts to also be the person responsible for conducting the investigation. And if that's the way that your district has it set up, although not ideal in the perfect world, that is fine. What is key, though, is that at a minimum, the investigator, the initial decision maker, and any decision maker on appeal all have to be separate people. You cannot have the same individual filling any 2 or more of those roles. They all have to be different. And so that's the key. You have some flexibility on the number of Title IX personnel, but you have to have separate individuals acting as the investigator, the initial decision maker on responsibility as to whether sexual harassment occurred, and then the appeal decision maker. We would generally recommend that the superintendent be the appeal decision maker. So essentially they are the last decision maker in the line of the grievance process. But as we all know, in small districts, that may not be possible because oftentimes the superintendent is your only administrator. So that person might be already designated as the Title IX coordinator who's handling the investigation. And so having them act as a decision maker is not possible under the regulations. And so under those scenarios, it might be that the board acts as a decision maker, either the initial decision maker or the decision maker on appeal. So you may have, just practically speaking, some limitations on what you can do as far as designating Title IX personnel. So that's kind of the gist of what we're getting as far as designation of Title IX personnel. We will cover, move on to training. I think that's a good segment or segue into training, because what's important under the new regs is that all of your designated Title IX personnel receive the required training under the new regs. And in terms of training requirements, I think of it in 2 ways. The first being what your Title IX personnel need to receive with respect to the required training, and then what your other employees, your staff members, should be receiving in terms of training. So I'm going to cover those 2 aspects of training. So with respect to Title IX personnel, The new regs require that they receive training in a number of different areas, and these are outlined in our template board regulation that we've provided to districts. And those include, they need to have training on the definition of sexual harassment, because they need to know what type of conduct may constitute sexual harassment prohibited by Title IX. So it's very important that they understand what the definition of sexual harassment is under Title IX. They also need to have training on how to identify sexual harassment. That's especially important with respect to the Title IX coordinator, who's going to be overseeing the district's efforts in complying with Title IX, as well as the investigator as well. They also should receive training on the scope of the district's education programs and activities, because as we know, the new Title IX regulations prohibit sexual harassment experienced by a complainant who is participating in or attempting to participate in the district's education program or activity in the United States. And so having a good sense of what the district's education programs and activities are in order to know if they need to respond to sexual harassment that occurs during those contexts. That's important. The investigator, whoever that is, whether it's your Title IX coordinator or somebody else, they need to receive training in how to conduct an appropriate, thorough and complete investigation, and how to move through the grievance process. So they should be receiving training on that. That would also include training on appeals and informal resolution procedures. So that might extend to all of your Title IX personnel, that type of training. Decision makers and investigators should be receiving training on making relevancy determinations. And what that refers to is the investigator in gathering evidence of the underlying sexual harassment, as well as the decision maker in determining whether sexual harassment has occurred in violation of Title IX. They need to determine what evidence is relevant to the issue of whether sexual harassment occurred. So we need to know, what does relevancy mean? When is information relevant to the issue and when is it not? And so having some of that training is important. Our educators and our staff typically don't have that type of training coming into the education environment. So it's important to provide that training. And then finally, all Title IX personnel should receive training on how to conduct their duties and their obligations impartially, and to avoid prejudgment of the facts, to avoid conflicts of interest and bias. So having some of that training is important. So that in a nutshell is the training that all of their Title IX personnel should be receiving. So it's quite extensive. Ideally, all of your Title IX personnel should have already received that training by August 14th, which was the effective date of the new regs, or as soon as possible thereafter. If you have not, if your Title IX personnel have not received that required training, we strongly recommend that you get that accomplished as soon as possible. If you need referrals to training resources, please contact our office and we can provide those to you. The second aspect of the training that I wanted to cover briefly is training that you might want to get for the rest of your staff, so your non-Title IX personnel. Hopefully all of you are aware that all of your staff are required to report sexual harassment that they have actual knowledge of or that they should have known about in terms of occurring in the district's education programs or activities. So it's important that they understand what sexual harassment is and how to identify it. And so that training also should be provided to all of your staff, because they are obligated under Title IX to report any alleged sexual harassment that they know about or should have known about. Again, if you need referrals for this type of training, please let us know and we'll direct you to resources. Again, just a reminder, please jump in with any questions or raise your hand. I'm just going to keep trucking along here with information. It looks like we have a question. Do we know if the training coordinated by SEEC in August covered all the topics required for training coordinator, investigator, and decision makers? If Kendra, if you're referring to the training that was received during the NDCEL boot camp, the answer to that question is yes. That training, I believe, would have ticked all of the boxes that are required for Title IX personnel training. But I'm not quite sure if you're not referring to that. I don't know off the top of my head, but we certainly can track that information down for you.
Amy? Looks like we have a chat. Can you send those resources for all staff training?
Yeah, I don't think we have it in the listed resources that you'll see later on in the presentation as far as the resources for training, but we will update our information on our Lunch and Learn resources page on the website, and then provide those to you as well after the presentation today. Okay, any other questions before we move on? All right, please feel free to jump in even if I've moved on to another question, or I should say another topic. Please feel free to jump in. Okay, so the next topic that I think potentially could cause a lot of questions or issues as we move forward in meeting the Title IX regulation requirements is what do school districts do when they become aware of conduct that could constitute sexual harassment, but the conduct occurs outside of the district's educational program or activity? So for example, what happens if two students, a student reports that they were a victim of sexual harassment after school hours and not in relation to a school activity or event. And the reason that this is relevant, I guess, to the discussion is that, just as a reminder, the Title IX regulations apply to sexual harassment that occurs when a complainant is participating or attempting to participate in a district educational program or activity in the United States. So if it's conduct that occurs outside of the district's educational program or activity, or occurs outside of the US, that type of conduct would not fall under the Title IX prohibition on sexual harassment. And so what happens then? I just got a call on a situation that occurred outside of school, but had an impact on the school environment. And so this school wanted to know what they need to do. And so before we kind of go down that path, I wanted to give you a sense of what does a district's educational program or activity, what does that mean? Well, that refers to locations, events, or circumstances over which the district exercises control over both the respondent, so the accused, and the context over which the sexual harassment occurred. So if the district does not exercise control over the respondent or the context over which the sexual harassment occurred, that would be considered outside of the educational program or activity. So it's quite broad, but it does have its limitations. So if the conduct occurs outside of a district educational program or activity, or for example, outside of school hours or at a location where the school has no control over the respondent or complainant, or where the conduct occurs. So Title IX likely doesn't apply. However, that doesn't mean that the district has no ability to do anything or take any kind of action. You may be able to take some action, but you're likely limited in any type of adverse action or disciplinary action you could take against the respondent. Because it doesn't constitute sexual harassment under Title IX, you likely are limited in what you can do as far as disciplinary action. But you might be able to offer supportive measures to the the victim, the alleged victim. So that could include counseling. It could include maybe making some adjustments to their class schedule, maybe giving them some flexibility in turning in assignments, giving them extra support in class to make sure that they are able to keep up with their educational requirements. So you might have some ability to do that. It also, even if it doesn't happen in the school environment, as all of you know, as teachers, administrators, school counselors, you all have mandatory reporting obligations under North Dakota law. And so even though the potential sexual harassment doesn't occur in the school environment or in an activity or program that the district exercises control, you may be, it may implicate your mandatory reporting requirements. And that's, those mandatory reporting requirements relate to conduct that could constitute child neglect or child abuse. Sexual assault is likely included in the definition of child abuse under those mandatory reporting requirements. So if you become aware of that type of conduct in terms of a juvenile victim, you likely are required to report those under the mandatory reporting requirements. So the point here is that even though you may not be required or able to take action or pursue the Title IX process, it may you may have some flexibility elsewhere in terms of mandatory reporting requirements and offering supportive measures to staff or students. We have a question on Title IX personnel, so I'll just take a quick minute to answer that. And the question is, would these other Title IX personnel need to be voted on, appointed, and mentioned in the board minutes each year? So if you are, if all of you have adopted, or your board has adopted our Title IX sexual harassment grievance procedure template, all of those individuals are identified by title in the regulation. And so the answer then would be yes, it would be part of the board action in adopting the board regulation. And so if there's any changes to those designated Title IX personnel, you'll want to make changes to the board regulation as well. Okay, so in addition to sexual harassment that might occur outside of a district education program or activity, another potential issue is that we see that districts may need to worry about or handle is, what about conduct that doesn't meet the definition of sexual harassment? So the Title IX regulations did expand the definition of sexual harassment, and that should be included in your sexual harassment grievance process that you've adopted as districts. It essentially has 3 prongs of what type of conduct could constitute sexual harassment under Title IX. If the conduct that has been reported does not meet any of those prongs in the definition, that likely means that you could not pursue the conduct under the Title IX grievance procedure. However, you may be able to address that conduct under other school board policies or code of conduct. And Title IX regulations do not prohibit districts from doing that. And so even though conduct wouldn't reach the definition of sexual harassment under Title IX, it might be a violation of your student code of conduct or your staff code of conduct. And Title IX does not prohibit a district from taking action or responding to that conduct if it's in violation of other school board policy or codes of conduct. The other thing to keep in mind is that Title IX requires districts to promptly respond to reports of sexual harassment in a manner that is not deliberately indifferent or clearly unreasonable in light of the circumstances. So if you receive a report of sexual harassment, you are required to promptly respond. That might mean that your response is making a determination whether it's conduct that, if true, would constitute sexual harassment under Title IX, and if so, pursuing the grievance process outlined in your board policy and procedures, or a determination that it does not meet the definition. And in that case, you may have be able to respond, like I said, under other board policies or codes of conduct. And so that would essentially meet your obligation to promptly respond to reports. And again, you may also be able to, even if you can't take action under other board policy or codes of conduct, you may still be able to offer supportive measures to your staff or students who may be alleged victims of conduct that is causing issues in the school environment. I'm just going to double check. Okay, one question is, if you have not yet adopted the Title IX policy or board regulation, should that be done? When should it be done, and does it require 2 reads? So if it has not been done, it should be done as soon as possible. You need to adopt a policy that's in line with the new Title IX regulations. So you need to do that as soon as possible. And our board regulations, whether it requires 2 readings, depends on your board policy adoption policy. And if you have our template, board regulations do not require 2 readings, I don't believe.
They do not.
So you wouldn't require 2 readings for board regulations. I think we did make some minor revisions to our anti-harassment and anti-discrimination policy, AAC, in light of the new regulations. And so any revisions to that policy, the umbrella policy, would require 2 readings unless you waive the 2nd reading in accordance with your policy adoption procedure. Another interesting question or interesting issue that comes up with respect to conduct that occurs, whether it occurs inside or with respect to a district educational program or activity. What happens if the parties involved are volunteers or a service provider that the district has hired to provide some sort of service to the district? What if the complainant is a volunteer or service provider, or whether the respondent is a volunteer or service provider? What obligation or abilities does the school district have to address that type of scenario? And I think it comes down to, again, whether the conduct occurred in a district educational program or activity, and whether the district had control over the respondent and the context in which the sexual harassment occurred. If so, the district is obligated under Title IX to respond, to promptly respond without deliberate indifference. So in terms of a volunteer or a service provider, if the alleged sexual harassment occurred in the school environment while the service provider or the volunteer was engaging in the activities that they were designated by the school district to provide, I think that possibly the district would be required to respond to that conduct. At the end of the day, what type of corrective action or adverse action they could take might be limited. So for example, in terms of a volunteer, It may be that at the end of the day, if the investigation determines that, and the decision is made that sexual harassment did occur, you may no longer hire that volunteer or have that volunteer or service provider come into your district to provide those services. So I think the answer to that is yes, you may have an obligation and ability to take action when you have a volunteer or a service provider as one of the parties in the alleged sexual harassment. Okay, the next issue that I wanted to cover relates to retaliation. Title IX prohibits districts from intimidating, threatening, coercing, or discriminating against any individual for the purpose of interfering with any right or privilege secured by Title IX. So kind of the traditional sense of retaliation. An individual cannot be retaliated against for exercising any right or privilege that they may have under Title IX. The other piece of retaliation that we often think about is you cannot take action against anybody for making a report or complaint, testifying or participating in an investigation, proceeding, or hearing under Title IX. So kind of the traditional sense of retaliation that we think of. But the additional issue under the new Title IX regulations is that a district is also prohibited from intimidating, threatening, coercing, or discriminating against any individual for refusing to participate in an investigation, proceeding, or hearing. So for example, if you have an employee who has knowledge of an allegation of sexual harassment, and you approach that employee to determine what information they know, and they refuse to provide the information or cooperate in the investigation, the new Title IX regulations prohibit the employer from disciplining that employee from refusing to participate. I think that's a big change from what we typically think of for workplace misconduct investigations. Oftentimes, employers have the ability to discipline an employee for refusing to participate in a workplace investigation, unless in the public employment setting, it would require the employee to incriminate themselves. You can't do that. But otherwise, outside of that type of a context, traditionally, the employer has the ability to expect that their employees will participate and cooperate in investigations. Under Title IX, you cannot, from my reading of the regulations, you cannot retaliate against an employee who refuses to participate. However, I think a district employer does have the ability to address an employee's failure to report sexual harassment that they either have actual knowledge of or should have known about. So this is a little bit different than disciplining for their refusal to participate in the investigation or a proceeding or hearing. All employees are required under Title IX to report sexual harassment they know of or should have known. And so if an employee fails to report, I think there is some flexibility for district employers to take adverse action against that employee for that failure to report. Also, as I mentioned earlier, conduct that constitutes sexual harassment could also constitute child neglect or child abuse under the mandatory reporting chapter of the Century Code, and that chapter is 50-25.1. And so if an employee is aware of conduct that constitutes child abuse, they might be, and they fail to report, not only would they be subject potentially to criminal and civil penalties under the North Dakota Century Code, but they may also be subject to discipline by the employer for their failure to adhere to their mandatory reporting requirements. So kind of something to keep in mind. It can be require you to draw some distinctions between what you can do or can't do in terms of retaliation. but it's something to note and be prepared to deal with. Okay, the last topic or issue that I had identified is the issue of confidentiality under Title IX. This issue, I think, is somewhat convoluted and can be complex in terms of the Title IX regulations. I think broadly speaking, the district has an obligation under Title IX to respect the confidentiality of the complainant and the respondent as much as possible. However, there's going to be the situation where some information is going to need to be disclosed to appropriate individuals or authorities. But districts should be careful anytime you're disclosing information regarding the identities of parties or witnesses involved in the Title IX grievance procedure, that you are being consistent with your legal obligations to keep information confidential, or even if you're not obligated to keep it confidential, that you take efforts to avoid disclosing that type of information unless you're required or need to do so to further to meet your requirements under the Title IX regulations. And I think where this issue is likely going to arise is related to student information, and also in terms of when students are providing factual information as witnesses and maybe providing witness statements. What can the district do to protect the identities of witnesses, as well as the respondent and the complainant, to make sure that they're not being improperly disclosed? So something to keep in mind on this issue is that Title IX provides equal access to evidence that's directly related to the allegations in the complaint to both the respondent and the complainant, as well as their chosen advisors. So the parties get to have access to the evidence that's directly related to the allegations of sexual harassment in the complaint. And so what that means is they get to have access to witness statements, likely, and likely to the identities of the witnesses that are providing those statements and the information. And in the grievance process that's outlined in the grievance procedure, in our template grievance procedure, and what's required by Title IX, there are essentially two instances where the district is going to be sharing information, evidence with the parties. The first instance is after the investigation has concluded, but before the investigation report is prepared and issued. The parties get to have access, equal access, to all evidence that is directly related to the allegations of sexual harassment in the complaint. So that would include witness statements. The second, and then they have an opportunity to respond to that evidence. And the key to this is that it's important that the parties have an understanding of the allegations of the complaint, as well as what the positions of the other party is in terms of the alleged sexual harassment. And then the second instance where the parties are going to be receiving information is after the investigation report is prepared by the investigator. A copy of the report is provided to both parties and their advisors. And that investigation report is going to be very detailed. It's going to address each of the allegations of sexual harassment with a determination of whether the investigation addresses each of those allegations. And then after they receive that, the parties are allowed to respond to that report. And so there's going to be disclosure of information about the other party, as well as witnesses that might be providing information. And that's okay under Title IX. The parties are allowed to have access to that. But the district is going to want to take steps to prevent further disclosure of that information beyond the parties and their advisors. So what are some things that a district can do to protect that information? So in receiving training myself on the new Title IX regulations and hearing from my colleagues across the country on districts handling Title IX grievance processes, I've heard of some good ideas that I wanted to share with you to prevent further disclosure of student information in particular. So for example, if you're providing access to witness statements to the parties, one of the things that you could do is redact in the actual statements, redact the identities of the student witnesses, or use generic identifiers like witness 1, witness 2, and then prepare a separate key that identifies who witness 1 is, who witness 2 is. And having and with instructions to the parties and their advisors that they should be keeping that information confidential. Is that an absolute barrier to improper disclosure? Likely not. But if you have separate documentation, I think the risk that a disclosure will be made goes down. It essentially adds an extra layer of protection. The other idea that I heard about, and is likely going to depend on the technology you have available, but one of the things that you could do is provide access to the evidence to the parties and to the investigation report electronically, and allow them to view the evidence in electronic form for a period of time so that they have the opportunity to review and respond to the evidence, but don't allow them to download it. That, again, is an extra layer of protection to prevent disclosure beyond the parties. The other thing you could do, I kind of like this one, is for information that you're sharing with the respondent and the respondent advisors, have as a watermark respondent, and then similar for the complainant, have a watermark on the documents marked complainant, so that in the event that information is disclosed to third parties, you may be able to identify where that disclosure came from. And then take appropriate action. One of the things that the new Title IX regulations require is that districts consider and factor in the interplay between the new Title IX regulations and the grievance process provided under the regulations, and FERPA and other applicable laws that may restrict the districts or may obligate the district to keep certain information confidential. So you're obligated to factor in and consider how all of that interplays. But what is clear from, at least from the Department of Education, is that compliance with the new Title IX regulations will not violate FERPA. And so if you are complying with your obligations under Title IX and following the required grievance procedure, you should not be in violation of FERPA. But having said that, you're going to always want to keep your obligations under FERPA in mind. Oops, I didn't mean to move forward. Okay. Looks like we got a question. Okay, so the question is in follow-up to an earlier question. I might just be looking too quick, but in the policies adopted under AAC and their regulations and exhibits, I only see the coordinator, the Title IX coordinator, specifically named and designated. I see reference to investigators, decision makers, and informal resolution facilitators, but only for training. To clarify, do we need to publish names of these other roles or designations? So I just want to distinguish, there is an obligation to publicize or publish the identity of the Title IX coordinator under the new Title IX regulations. So you have to publish on your website and to your students, staff, and parents who the Title IX coordinator is, and for purposes of knowing where to submit complaints and reports. As far as designation, so there's a difference between publishing who those individuals are and actually designating them. The R template board regulation for the Title IX sexual harassment grievance procedure, I believe, does instruct or direct districts to identify who the actual investigator, decision makers are in the actual board regulation by title. I could be wrong about that, but I'm pretty certain that that's the case. Actually, you know what? I have it right here, so let me just thumb through here. So absolutely, the Title IX coordinator must be identified by name, title, and you need to include their contact information and publish that information in accordance with the Title IX regulations. Let's see. So for the investigator in our template board regulation, AAC-BR2, we do direct the board to identify who the investigator is by title. Again, it's possible that your investigator is also going to be your Title IX coordinator, the same individual, and that's okay under the new regs. But we do, in our regulation template, we do direct to list by title. And Shauna, page 10 is an example of that. So page 10 of our template board regulation talks about the investigation and the investigator and the investigation report. Page 9 as well, that kind of deals with the formal resolution procedure, and we direct the board to identify the investigator by title. Let's see.
Just a point of clarification, outside of the policy, they are not required to publish on the website this designee or investigator, their name, just like they would have to for the Title IX coordinator.
Yes, thank you for that clarification, Rebecca. And that's she said it more eloquently than I did initially. There's a distinction between being required to publish who those individuals are and designating those individuals by title and name in your board regulation. In the board regulation, at least in our template, and we would recommend, even if you don't use our templates, that you identify those folks by name and title. And that goes for all the way from the Title IX coordinator all to investigator, informal resolution procedure facilitator, the two decision makers, the initial and the appeal. Those should all be designated specifically in your board regulation. One thing that just popped into my head on that, you know, there, especially in smaller districts where you are limited in how many Title IX personnel staff you actually have. You have to designate an employee as your Title IX coordinator, at least one employee. But let's say that you have a situation where it would be inappropriate or to avoid an appearance of impropriety, not to have your designated investigator or your designated decision maker act in that role in that particular situation. And so you are allowed under Title IX to bring in third parties to act in those roles. This is separate from your Title IX coordinator, which again needs to be an employee of the district. But beyond that, your other Title IX personnel, you may need to bring in a third party in a given situation in order to avoid a conflict of interest, avoid partiality, avoid bias, and to avoid prejudgment on the facts. Kendra, yes, so where the board regulations say the titles in bold, we should replace with who that is. Yes, we would at least have their title, so building principal or superintendent. But I think you don't necessarily have to name their name, but at least the title. And if you have multiple building principals, obviously you're going to want to clarify that further so that we know who that designated individual is. Let's see. One more question. So the Title IX coordinator cannot be the investigator. No, the Title IX coordinator can be the investigator. That's okay. Ideally, you would have 5 different individuals as Title IX personnel. So you have your Title IX coordinator, who again is responsible for compliance on behalf of the district with all of the Title IX obligations. And so it's a pretty significant role. And so if possible, having somebody else designated as the investigator who's responsible for conducting the Title IX investigations is ideal. But the reality in most of our districts is that you don't have enough staff to do that. You don't have the staff, especially now during the pandemic. It's difficult to potentially designate 2 different individuals. So it's okay to have the Title IX coordinator also be conducting investigations. What's not okay is that the investigator and the decision makers need to all be different individuals. You can't have the investigator also be the same individual that's going to be deciding, making the initial decision on whether sexual harassment occurs, or the decision maker on appeal. You also don't want to have the same decision maker be the decision maker on the issue of whether sexual harassment occurred, as well as the decision maker on appeal. Those need to be 2 separate individuals or 2 separate entities if you have your board as your appeals decision maker. I hope that's clear. Shauna, if you want to discuss that further, you can certainly give us a call here at the office. Okay, we're winding down now. One thing I wanted to say, thank you so much for your questions. I know we only have a quick hour, and Title IX is complex, and there's been a lot of changes in what districts need to do. So we fully expect that additional questions are going to come up as you guys work through all of this in your districts. But one thing I wanted to mention before I hand it back to Rebecca is that you know, we prepared the our board regulation template to be as a guide, but there are specific decisions that districts need to make to tailor that grievance process to what will work in your district, keeping in mind the general requirements that Title IX has. And so it is strongly recommended that you consult with, it's not meant to be a substitution for consultation with legal counsel. So you should be at least touching base with your district legal counsel on the new Title IX regulations, as well as your obligations on, and then especially when you're in receipt of a Title IX complaint or report. Having your district legal counsel there to assist as you move through the process is extremely important. And so we would just reiterate not being afraid or hesitant to do that. One question, who could be the facilitator of informal resolution? An example of what position that could be in the school. So the facilitator of informal resolution, our template board regulation has a whole section on the informal resolution process and what that entails. I think in most districts, it's likely going to end up being the Title IX coordinator who is also that facilitator, and that's okay. There's nothing, the Title IX regulations don't prohibit that. But I think, again, the Title IX coordinator has significant responsibility already under Title IX. And if that Title IX coordinator is also going to be acting as the investigator, it may make more sense to have somebody else facilitate an informal resolution procedure, although, again, it's not required. So another administrator would be a good idea for facilitating the informal resolution process. You could hire an outside mediator depending on what the informal resolution process will look like for that particular situation. You could have an outside third party come in depending on what that informal resolution procedure will look like. So it's hard to, you probably won't want to designate instructional staff for that. You'll want to stay away from that. But some other administrative type position would likely be appropriate. And then also being prepared to call in or retain third parties in particular situations, depending on what your ideas for a good informal resolution would be in a particular situation. With that, I think we're nearing the end of our time, so I'm going to hand it back over to Rebecca, and she's going to give you some information on available resources.
Okay, thank you, Amy. Per law, school districts must have a policy that states they do not discriminate on the basis of sex in the education programs or activities they operate, including admission and employment, and that they are required by Title IX and its corresponding regulations not to discriminate in such a manner. The NDSBA has created multiple policy templates and resources for districts to utilize regarding the sexual harassment regs. The policy descriptor code districts will want to refer to is AAC, as mentioned before, the non-discrimination and anti-harassment policy. This is the general school discrimination and harassment policy, but accompanying this policy, there are two required board regulations that outline grievance procedures for harassment. These are AAC-BR1 and AAC-BR2. AAC-BR2 Title IX sexual harassment grievance procedure was created to comply with the updated regs and should be used to resolve sexual harassment grievances, whereas AAC-BR1 discrimination and harassment grievance procedure should be used to resolve all other forms of discrimination, harassment, and retaliation complaints by and against students, parents, and third parties. NDSBA also has a couple exhibits that reference the Title IX and any requirements outlined in the final rules. One is AAC-E3, discrimination and harassment training requirements for employees. And the other template is AAC-E5, notice of Title IX sexual harassment complaint. The purpose of this written notice is to help ensure that the nature and scope of the investigation and the district's procedures are clearly understood by all parties and at the commencement of the investigation. Upon receipt of a formal complaint, districts must send this written notice to both parties, the complainant and respondent, and of all the allegations. As you can see on the screen, there are many different, or there are some additional policies and resources that may be useful. Amy, would you like to make any additional comments on any of these?
So yeah, and actually the reference to the bullying policy, I forgot to mention. So when we were talking about conduct that may not meet the definition of sexual harassment under the Title IX regs, one of the other board policies or regulations that might cover that type of conduct could be the bullying policy. And as we know, this last legislative session, the North Dakota legislature expanded the definition of bullying to cover cyberbullying that occurs off campus. So even though it's possible that you'll have conduct that doesn't meet the definition of sexual harassment, but might constitute bullying. And so the district would be obligated under the North Dakota law and your own bullying policy to take action and respond. And so I would just mention that that's another potential avenue of redress that you would have. And then just a quick mention, in addition to the policies and regulations on the slide, Rebecca has provided some links to some other resources regarding Title IX that if you haven't looked at them, it might be helpful just to kind of further cement some of these concepts in your mind. And we've indicated those on the slide too. There are likely many others. And we're also, hopefully all of you are registered for our virtual law seminar that starts next week. It's going every day. We're having presentations. And on, I think it's Wednesday, pretty sure, we have Chris-Ann Norby-Johnner from the Vogel Law Firm. She is going to do a presentation on Title IX and is going to go into more in-depth of an overview of the new Title IX regs and go into some of these issues even further. So if you aren't registered, please think about registering, because it'll give you some even more training and information on Title IX. I think that's about it. We do have, let me just see, we do have one training. Okay. When is the training for Title IX personnel required by? So as I mentioned earlier, the new Title IX reg became effective on August 14th, 2020. So a few months ago. You know, as of that date, the new regulations required that your Title IX personnel have the required training. So technically they're required to have it as of that date. But because of the timing of the issuance of the regulation, as well as the significant other issues that all of us are dealing with respect to the pandemic, our recommendation was to get the training done as soon as possible. Practically speaking, your Title IX personnel are going to need the training when they receive reports or complaints alleging sexual harassment. So at the very least, they need to have that training in order to deal with a report or complaint of sexual harassment. So that could come at any time. And so we would recommend, if you have not gotten that training for your Title IX personnel, that you do that as soon as possible, because you never know when you're going to get a complaint, and you're required to promptly respond. And likely wouldn't be able to arrange training fast enough. So go ahead and get that training started and arranged if you haven't done so. I think that's it for me.
Okay, so as Amy said, just a final couple thoughts to wrap up. These new regulations are complex and ever evolving, so there will likely be updates to the templates along the way. We do apologize in advance for all the paperwork, but the good news is that the board regulations, the Title IX board regulation, can be adopted by your board in one reading, and the exhibits require no board action. You will want to confirm this with your board adopting procedure policy, but typically that is the case. Okay, well, this ends our training today. Remember that this webinar recording, slides, and the associated resources will be available at www.ndsba.org under the resources tab. Our next Lunch and Learn is set for November 18th at noon. We are currently working in our office on the next 3 months of topics, and we'll send them out to you to register for in early November. Registration information can always be found for the NDSBA Lunch and Learns on the NDSBA website under the resources tab. If you have found this information useful today, please let others know so that they can watch it and possibly join us next time. Thanks again to our sponsor, Software Unlimited, and for all of you for joining us today. We truly appreciate your participation. Contact our office at 1-800-932-8791 if you have questions on any of the information you heard today. We look forward to seeing